Hello and welcome to Compliance Briefs on Sanctions Compliance Program. In this presentation, we explore the Sanctions Compliance Program, starting with what is Sanctions Compliance Program and what should this include. We will cover topics such as sanctions risk assessment, sanctions screening, reporting obligations, training and awareness, record keeping and mitigating measures, all crucial for designing an effective sanctions compliance program. What do we mean by a sanctions compliance program? The Sanctions Compliance Program constitutes the flagship of the firm that safeguards against sanctions-related risks. It consists of the sanctions policy, the sanctions risk assessment, the policies, procedures, systems, and controls, tailored training, sanctions screening, clear reporting procedures and record-keeping requirements. The Sanctions Compliance Program should be documented in a sanctions manual that should be effectively communicated to all members of staff. It is very important that the established policies, procedures, systems, and controls commensurate to the sanctions risk of the firm and satisfy the provisions of the sanctions by ensuring designated persons are immediately identified, their assets are frozen, reporting procedures apply and prohibited activity is identified. The sanctions risk assessment is the cornerstone in identifying, assessing, and mitigating sanctions-related risks and emerging threats. It should follow a three-tier approach, consisting of the firm-wide sanctions risk assessment, the client sanctions risk assessment, and the transactions involving goods risk assessment. The firm-wide risk assessment aims to identify which business lines and services provided are more vulnerable to sanctions-related risks, what sanctions risks emanate from your clientele and its counterparties, if and how the transactional method of your firm is prone to sanctions-related risks, and how the way you conduct your business could be exploited for sanctions breaches or circumvention attempts. The results of the firm-wide risk assessment will guide the firm to the adoption of adequate, appropriate, and proportionate measures and controls and to concentrate its efforts and resources to those areas. To facilitate the process, ICPAC has issued a guidance on how to conduct a sanctions firm-wide risk assessment, which you are strongly advised to incorporate in your risk assessment process. The client risk assessment enables the firm to identify the sanctions-related risks arising from the following: activities of the client, including clients who are designated persons, dealing with products included in export controls or dual-use goods, dealing with goods contained in the common high-priority list, etc. Risks arising from the geographic locations of operation or origin of the client, such as jurisdictions under restrictive measures or embargoes. Risks arising from the services provided or requested by the client and how susceptible they are to sanctions evasion or circumvention attempts. Risks related to delivery channels and the way of conducting business, as well as related to the characteristics of the client, for example if related to a PEP, has complex structure or a structure that favors anonymity, are also captured by the client risk assessment. Risks attached to the specific characteristics of an individual client, for example if the client is a PEP, if the legal entity belongs to a complicated group structure allowing anonymity, etc. Finally, risks related to the transactional behavior of the client, such as complex transactions or transactions passing through multiple jurisdictions, should also be identified. To facilitate the process, ICPAC has issued a guidance on how to conduct a client risk assessment, which you are strongly advised to incorporate in your risk assessment process. For clients dealing with goods, conducting a transaction risk assessment is essential. This assessment could take into consideration factors such as the goods themselves, the target, the end user, the end use, the volume of the contract and transactions payment channels, as well as other involved parties. When assessing the goods element, you should consider whether the transaction involves any dual-use goods, goods contained in the common high-priority list and goods contained in the economically critical goods list, goods subject to import-export controls, or goods that can be dismantled and rediverted. Goods that do not fall within the above-mentioned categories could be assessed as lower risk. For example, skin care products or clothes could be assessed as having a lower risk element for sanctions breaches as opposed to engines. Target usually refers to the client receiving the products or the client supplier. When assessing this element, you may consider the background and structure of the client supplier. For example, small or medium enterprises which are family-owned with clear ownership structures may receive a lower risk element as opposed to large enterprises with multiple levels of ownership. In assessing the end-user factor, consider who the final user of the products will be and whether an end-user certificate could be provided. For the end-use factor, consider what the final use of the good will be. Are the goods intended for civilian or military use? Regarding the volume of the contract and transactions factor, consider the amount of the contract transaction. Smaller contracts typically pose lower risk. Assess the payment method. Does it align with the client's typical business practices and geographical norms? For example, using an intermediary for delivery and a third-country bank for payment might be standard in some countries but unusual in others, affecting the risk level. Additionally, you should consider whether there are any other parties in the transaction that could affect the transaction risk. It is stressed that, even if a client risk profile is not classified as high for sanctions risk, a specific transaction may still be captured under the sanctions provisions. For more information on how to conduct transaction risk assessment, you may consult guidance to ICPAC members on sanctions and restrictive measures. Of utmost importance is the sanction screening procedure. Sanction screening allows for the effective identification of designated persons and prohibited activities. Sanction screening is divided in client screening and transaction screening. Client screening serves to identify designated persons. As such, it is a requirement that applies to all clients, irrespective of the risk profile of the client. Client screening should be conducted on all new clients and ongoing monitoring and change-driven screening on existing clients, including every time there is an update to the sanctions lists. Based on ICPAC Sanctions Directive, apart from the client, screening procedures should be performed on any other related party to the client, including but not limited to the directors, beneficial owners, signatories, counterparties, suppliers, end users, etc. You should bear in mind that limited availability of identifying details suggests poor KYC/CDD procedures, and in no way can it justify dealings with designated persons. Transaction screening refers to the screening of a movement of value, including funds, goods, or assets between parties or accounts in order to identify possible sanctions targets via the screening of the payment information. If you provide directorship or bank management services, you should perform real-time transaction screening, meaning before the execution of the transaction. On the other hand, transaction monitoring or post-transaction screening refers to assessing the transaction with the purpose of identifying unusual patterns. Based on ICPAC Sanctions Directive, you have the following reporting obligations. True match reporting. Sectoral sanctions reporting. Sanctions breaches circumvention reporting. The true match reporting obligation arises where a true match against the sanction lists is identified irrespective of the ownership. The obligation is without delay. ICPAC has issued a reporting template to facilitate the procedure. The template can be found on ICPAC's website via Compliance Circular 17/22. The sectoral sanctions reporting obligation arises where the firm services clients that have activities captured under the sanctions provisions. The obligation is again without delay. ICPAC has issued a reporting template to facilitate the procedure. The template can be found on ICPAC's website via Compliance Circular 2023. The sanctions breaches circumvention of sanctions reporting obligation arises where the firm identifies a breach of sanctions or an attempt or actual circumvention of sanctions. The obligation applies without delay upon identification of the breach circumvention attempt. In addition, and notwithstanding any reporting obligations towards ICPAC, in cases where the sanctions provisions impose reporting obligations towards the competent authorities, firms are required to comply within the prescribed deadlines. When reporting to competent authorities, firms should also notify ICPAC of the said reporting. The training program constitutes a crucial element of an effective sanctions compliance program. For maximizing results, the training program should be guided by the results of the sanctions firm-wide risk assessment and tailored to the needs of each department. Different levels of staff and different nature of work require different training. The training program should not be concentrated only to the policies and procedures of the firm, but should also include new threats, new trends, vulnerabilities, new tactics and circumvention techniques, as well as new requirements. A comprehensive training program ensures that the sanctions compliance program remains relevant and fit for purpose. All information and data related to sanctions should be kept for a period of 5 years following the end of the business relationship or after the date an occasional transaction was completed. The format, depth, and method of record keeping should allow for the production of an audit trail of the actions taken in relation to sanctions. Retrieval procedures should be put in place that allow timely and without delays access to the records and information retained. In a nutshell, for a concrete and effective sanctions compliance program, you should, at a minimum, take the following measures to mitigate risk. Ensure that the tone is set at the top and that senior management completely understands the firm's sanctions obligations. Prepare adequate and effective policies, procedures, and controls and establish a system for updating of such policies, procedures and controls guided by planned periodic or change-triggering updates. Communicate the policies and procedures to all staff and related third parties, making sure that they are well explained and understood by all. Design an appropriate training program for all level of staff that can pick up and fill in any gaps. Design a screening process and ensure that any associated third-party due diligence procedures align with it. Ensure established procedures, including escalation process, for handling business relationships and transactions presenting a high sanctions risk. When necessary, based on the firm's size and the nature of the services provided, conduct independent internal or external auditing of the sanctions compliance program, ensuring that it always remains relevant and any deficiencies are identified and remedied. Finally, ICPAC has issued a number of guidance notes pertaining to an effective sanctions compliance program in an effort to help firms understand their compliance obligations and risks and implement effective policies, controls, and procedures to manage and mitigate those risks. The guidance notes can be located on ICPAC's website under the tab Monitoring and Compliance in the Compliance Guide section. I hope you found this useful. For any queries, you may contact us via email at compliance@icpac.org.cy. Thank you and goodbye.